Most kids going into college are 18 and registering to vote. And by registering to vote, that means that they are able to be part of a jury in a trial. But do these young adults really understand what goes into a trial and how it works? There are multiple parts to a trial. There's before the trial, during the trial, and then even after the trial, there's things that can happen. Most of the work that a prosecutor puts into a trial is before the trial, as a matter of fact. A trial starts with the investigation, and according to the United States Department of Justice, in January 28th, 2022, the prosecutor works with many different agencies and looks at the evidence, direct and circumstantial, to determine if they can move forward to charging. And according to the United States Department of Justice, on the 2nd of March, 2021, once they decide to charge someone, if there's enough evidence, they then have to present this case to a grand jury. And a grand jury is made up of 16 to 23 people. And these people then look over and decide if all the evidence posted was enough to take to trial, if there's enough probable cause and whatnot to take it to trial. And then if they decide yes, then they move to trial, and if not, then they dismiss. According to initial hearing and arraignment by the United States Department of Justice on July 6, 2020, they then will be placed in front of a magistrate judge, in which they will plead guilty or not guilty. They're being informed of their rights, and they get an attorney, in which they move forward, and then they also get their bail, in which bail is set between high and low, and the judge has to have a separate hearing in which they talk to him about this defendant and his ties to the community and whatnot. Then after that, they move to discovery, and according to the United States Department of Justice, on July 6, 2020, the prosecutor then has to become familiar with the case. And by doing this, they have to speak to witnesses, they have to view the evidence, and they have to make a strategic gameplay. They talk to the witnesses and basically cross them before they even get to trial to see how they will respond in a trial. Once they do this, they then look over their case and decide if they want to do plea bargaining. And according to the United States Department of Justice, in the 17th of December 2014, a prosecutor decides if they have a strong case. And if they have a strong case, they will talk to the defendant and determine whether he wants to move forward and take a plea in which he can get a lesser sentence and avoid the trial. In which, if he does this, then it moves straight to sentencing and there's no trial. If a defendant decides they do not want to take a plea, then they move to the preliminary hearing. And according to the United States Department of Justice, July 6, 2020, in the preliminary hearing, they'll plead not guilty, in which they will present their evidence and they will cross their witnesses, and it's basically a small trial in which they will decide if there's enough information in front of the judge to move forward. Now, a defendant can waive their right to a preliminary hearing, according to the United States Department of Justice on the 6th of July, 2020. If they then decide that there's enough information, they schedule the trial. That's not all before the trial. According to the United States Department of Justice, on the 17th of December, 2014, there's also pretrial motions in which can stall the case. A motion is an application to a court by a prosecutor or defense in which they want the court to make a decision about something before the trial. There are a couple different types of motions. There's a motion to dismiss, in which if there's not enough evidence, they will dismiss the case. There's also a motion for change of venue, in which this happens when a very public case has a lot of publicity and there's no way to have an unbiased opinion. Then they will move to a trial. And according to the United States Department, trial on July 6, 2020, they then will present all their evidence to a jury, in which the defense and the prosecutor bring forth all their evidence and plead their cases. There's the opening statements, in which they will initially address the jury, and then there's objections throughout. There's hearsay, in which the information that is found is not pertaining to something they saw directly. It's secondhand information. And then there is relevance, in which the information they got was not relevant to the case. And then there's the closing statements, in which they will finally plead their case with all the evidence and how it ties into their case. Now, the jury selection, which is relevant to young students, you can be released from jury selection. The defense and the prosecutor have the ability to turn away a certain number of jurors each, in which they can ask them questions to see how their bias is and to help them with their case. Once they have done their closing statements, their jury decides to deliberate and they have to unanimously reach a verdict. And they can do guilty or not guilty. If they cannot reach a verdict, it is a mistrial, in which if they reach not guilty, the person is released, and if they reach guilty, then the person is sent to prison. Then, according to the United States Department of Justice, on the 17th of December 2014, in post-trial deliberations, there's still some motions that can be made after the trial. There's a motion for a new trial in which they believe there was bias or they feel like they were wrongfully convicted. And these are rare for these motions to be accepted. Once they move past this, they then move to the sentencing. And according to the United States Department of Justice, on the 7th of October 2020 sentencing, a judge then looks at the information that is presented and chooses between a minimum and a maximum for a defendant to go to prison for, in which they can also get the death penalty if they've committed a capital offense. And then finally, there's the appeal. And according to the United States Department of Justice, appeal on July 6, 2020, that if there's a person who feels like they are wrongfully convicted, they can appeal and request a new trial, in which this is very rare for it to happen. And if this does happen, they also could appeal to the United States Supreme Court, but the United States only does a couple of these cases a year. These young students view the justice system so simply and don't understand the part and the role that they play in it themselves, in which by being in a jury, and a jury is a very complicated, you have someone's life in your hand. You decide how they move forward. And it's a very tough job to place on a young student, but many of them will be called to do it, so they need to be informed.